Hello and welcome to my presentation on concurrent delay effect on entitlement to EOT arises in construction contracts. I am delighted to talk today on the various aspects of this important topic. The aim of this lecture is to get understanding and concept of the protocol prepared by the Society of Construction Law UK. This protocol has been prepared for determining extension of time and financial relief for delay and disruption. The protocol provides guidelines to all parties to the construction process when dealing with delay and disruption matters. I will start with the meaning of concurrent delay. Concurrent delay is the concurrence of two or more delay events at the same time, that is, employees risk event, contractor risk event. The effect of these delays are felt at the same time. For current delay to exist, each of the employer risk event and the contractor risk event must be an effective cause of delay to completion. This means that the delays must both affect the critical path. Where contractor delay to completion occurs or has an effect concurrently with employer delay to completion, the contractor's concurrent delay will not reduce any extension of time which is due. Concurrent delay may occur at the commencement date when the employer fails to give access to the site, but the contractor has no resources mobilized to carry out any work. However, it can arise at any time. The term concurrent delay concerns the situation where two or more delay events arise at different times. However, the effects of them are felt at the same time. In both cases, concurrent delay becomes an issue when each of an employer delay event and a contractor risk event will lead to delay to completion. This issue has two complications. Practical complication. From a practical perspective, the analysis of the effects of the delay events is simpler. If it considers only those events that will result in delay to completion rather than a consideration of all events in the program, so that the grant of an EOT follows the outcome of the critical path analysis. The Protocol of Society of Construction Law recommends this approach during the concurrency of the project to allow the timely application for an assessment of EOT. Legal complications. For legal complications, for legal perspective, to simplify, see the following example. Suppose a contractor risk event results in 5-week contractor delay to completion, delaying the contract completion date from 21st January to 25th February. Independently, and a few weeks after, a variation is instructed on behalf of the employer, which, in the absence of the preceding contractor delay to completion, would result in employer delay to completion from 1st February to 14th of February. To explain this scenario, there are two further explanations. First view, supported by older English appeal courts cases. The two events are both effective causes of delay to completion for the 2 weeks period from 1st to 14th February, because they each would have caused delay to completion in the absence of the other, with the subsequent delay from 15th February to 25th February caused by the contractor risk event alone. This view provides that if the failure to complete the works is due in part to the fault of both the employer and the contractor, liquidated damages will not apply. It can be argued that both the employer risk event and the contractor risk event are in part the cause of the delay to completion. Second view position of lower English courts. Other view is that the implied delay will not result in the works being completed later than would otherwise have been the cause, because the works were already going to be delayed by a greater period because of the contractor delay to completion. Thus, the only effective cause of the delay to completion is the contractor risk event. This is the consistent position of recent lower English court decisions. SCL protocol recommendation. The protocol recommends that where an EOT application is being assessed, the employer risk event should be seen as not causing delay to completion, and therefore there is no concurrency. Concurrent delay only arises where the employer risk event is shown to have caused delay to completion, or, in other words, caused critical delay, that is, it is on the longest path to completion. The protocol cautions that this recommendation would have to be reconsidered where an appeal court to take a different approach to this issue. In considering whether concurrent delay exists, the protocol recommends a common sense approach to delay analysis. In particular, the protocol recognizes that delay analysis is rarely precise down to the day or even few days. The application of common sense requires that the margin for imprecision should be taken into account in reaching a conclusion on concurrency. Dealing with concurrent delays. Where concurrent delay has been established, the contractor should be entitled to an EOT for the employer delay to completion, dealt with in accordance with core principle that the contractor delay should not reduce the amount of EOT due to the contractor as a result of the employer's delay. An employer should be aware that if it instructs a variation after the contract completion date where the failure to complete by the contract completion date has been caused by contractor delay, the employer may lose its entitlement to liquidated damages. If the contractor then accelerates to recover the contractor delay to completion at its own cost, and that results in the variation and employer's event becoming the effective cause of delay to completion. Employer delay to completion does not exonerate the contractor for all its delays prior to that employer delay to completion occurring. The effect of the employer delay should be assessed in accordance with the core principle 5 of SCL protocol, and any EOT determined due should simply be added to the contract completion date. The SCL protocol approach to dealing with concurrent delay aims to provide contracting parties with clarity and certainty about entitlement to EOT. The SCL protocol position on concurrent delay is influenced by the English law prevention principle, by virtue of which an employer cannot take advantage of the non-fulfillment of a condition, for example, to complete the works by a certain date, the performance of which the employer has hindered. The protocol's approach to the treatment of concurrent delay, once established, prevents arguments about whether an English delay, whether an employer delay acting concurrently with a contractor delay actually hinders the progress of the contractor in any way. Thank you.